Mr. Anurag Batra, and my esteemed colleagues from the profession, Pratibha Anand Prasad, in-house counsel, Mr. Gemawat, Mr. Sudhir Mishra, Mr. Safir Anand, Ms. Seema Jingan, and all other distinguished members, participants, and delegates. The topic assigned to me is the entry of foreign law firms in India and other movements in the legal industry. It's very strange that we are discussing entry of foreign law firms in India. The largest and number one powerful country in the world is the United States. And I think you are all aware that in the US, a lawyer cannot practice in another state in the United States. He has to have some examinations or some tests or some interviews in order to enable him to practice from one state to another state. In India, we still have a liberal regime so far as foreign lawyers are concerned. Even today, without even the amendment of the Advocates Act, a foreign lawyer can appear in the Indian courts, of course with the permission of the courts. Now, what is the history of this movement which is going on to allow the foreign law firms to practice in India? The whole issue started sometimes in early 1990s, when there was liberalization of the economy. So this movement started that there should be liberalization in the field of legal services also. The Indian legal profession resisted this move and resisted very vehemently. I was the General Secretary of the Bar Association of India at the relevant time with Fali Nariman as the President. And we had the first conference in 1994 just to discuss the issue of what we call the impending entry of the foreign lawyers in India, because the government was very keen that the legal services sector should be opened up. We opposed the entry of foreign law firms on various grounds, but mainly that the Indian legal profession is quite different and distinct, you see, from the legal profession in other countries where it is no longer a profession, it has virtually become a business, you see. Legal profession had become a business in the other countries, and we said that would adversely impact and affect the image of the legal profession, because our heritage is different, our culture is different. Our father of the nation was a lawyer, our first prime minister was a lawyer, our first president of India was a lawyer, you see. The deputy prime minister was a lawyer, the Governor General Rajgopalacharya was a lawyer. So we had that heritage that the legal profession was always in the forefront of taking up causes, and in this case the cause was the struggle for the freedom, and that is where the legal profession played a very pivotal role. That was one reason why we opposed, but the second reason was that Indian legal profession was not prepared, say in early 90s, to face the onslaught of foreign law firms coming into India. Already the experience had been with the firms of the chartered accountants that the big four had virtually monopolized the entire chartered accountancy work, the audit work, you see, in India. And it was confined only, you see, to these big 4 or 5, and they completely took over the chartered accountancy profession. So fearing that sort of a debacle which we may face, we resisted, this. And we resisted, continued to resist till 2014 for 20 years, from 1994 to 2014. During this period, we saw the emergence, of law firms in India. And these law firms were headed by comparatively young people. They had some resources also available to them. They were familiar with the technological advances, which had been made. And during a short period of 10 to 15 years, the Indian legal firms became, a force to be recognized with. And today the position is that Indian legal firms, or even the Indian legal profession, is second to none in the world, Therefore, in 2014, we told the government very clearly, we told the Bar Council of India very clearly, we mean, the Bar Association of India, and by that time the Society of Indian Law Firms had also been set up in year 2000. We said that we are prepared, you can open the legal services sector to the foreign law firms, but do it in a phased manner. Phased manner as was done, in many other jurisdictions, including Singapore, Hong Kong, Japan, and other countries. In 2014, we took this stand. And despite the pending litigations, there was a litigation way back 2009, Lawyers Collective, in which the Bombay High Court held, that the foreign lawyers have no right to practice in India. And the Reserve Bank of India was castigated, for allowing some 3-4 big law firms, including White and Case, Chadbourne Park, and a couple of others, to set up their liaison offices in Bombay. And these law firms had taken over the entire floors in 5-star hotels like Taj and the Oberoi, and they were running their regular establishments. So Bombay High Court held that this is impermissible and it is against the existing law. That was in 2009. Then came the Madras High Court judgment in Balaji versus Bar Council of India. And in that, the Madras High Court, while broadly agreeing with the Bombay High Court judgment, did give some limited relief to foreign lawyers that they could come on fly-in, fly-out basis to do some casual work, to give some advice to clients whom they represent, and also held that in arbitration proceedings, the foreign lawyers should be permitted to appear either as a counsel or even to act as arbitrators. Now, the Bar Council of India took up this matter to the Supreme Court, and the judgment of the Supreme Court was delivered in the last year, that is in 2018. And that is very significant because today it is that judgment which holds the field, and it is based on the existing provisions of the Advocates Act. And I think it is best to get it from the horse's mouth as to what the Supreme Court has said and laid down as a law. And the issue before the Supreme Court, this judgment was delivered by a division bench of the Supreme Court by Justice A.K. Goyal and Justice U.U. Lalit. They say the issue involved in this batch of matters is whether foreign law firms, stroke lawyers, are permitted to practice in India. So this was the issue. This is the very first sentence of the judgment. And I will read out to you the conclusions of the Supreme Court. Their Lordships say, consideration of the issues. We have considered the rival submissions. Questions for consideration mainly arise out of the directions in para 63 of the Madras High Court judgment, which have already been quoted in the beginning of this judgment. Whether the expression practice the profession of law includes only litigation practice or non-litigation practice also. Number two, whether such practice by foreign law firms or foreign lawyers is permissible without fulfilling the requirements of the Advocates Act and the Bar Council of India rules. Three, if not, whether there is a bar for the said law firms or lawyers to visit India on fly-in, fly-out basis for giving legal advice regarding foreign law on diverse international legal issues. Then whether there is no bar to the foreign law firms and lawyers from conducting arbitration proceedings and disputes arising out of the contracts relating to international commercial arbitration. Then a side issue was whether BPO companies providing integrated services are not covered by the Advocates Act and all that. And what is held by their Lordship is that they say that we have already held that practicing of law includes not only appearances in the courts, but also giving of opinions, drafting of instruments, participation in conferences involving legal discussions. These are parts of non-litigation practice, which is part of the practice of law. Scheme in Chapter 4 of the Advocates Act makes it clear that the advocates enrolled with the Bar Council alone are entitled to practice law, except as otherwise provided in any other law. All others can appear only with the permission of the court, authority, or person before whom the proceedings are pending. The prohibition applicable to any person in India other than advocates enrolled certainly applies to any foreigner also. So this clinches the issue that only those who are enrolled, and who can be enrolled? Only Indian citizens, that is under the existing law. Therefore, it clearly debars, you see, the foreign lawyers to practice law in India. Then visit of any foreign lawyer on fly-in and fly-out basis may also amount to practice of law if it is on regular basis. The Supreme Court goes one step beyond, you see, what even the Madras High Court had held. A casual visit for giving advice may not be covered by the expression practice. Now, whether a particular visit is casual or frequent so as to amount to practice is a question of fact to be determined from situation to situation. And the Bar Council of India or Union of India are at liberty to make appropriate rules in this regard. Then they give directions to the Union of India and also. Then even about arbitration, their Lordships say that it is not possible to hold that there is absolutely no bar to a foreign lawyer for conducting arbitrations in India. If the matter is governed by particular rules of an institution, or if the matter otherwise falls under Section 32 or 33 of the Advocates Act, there is no bar to conduct such proceedings in prescribed manner. If the matter is governed by an international commercial arbitration agreement, conduct of proceedings may fall under Section 32 or 33 of read with the provisions of the Arbitration Act. Even in such cases, the code of conduct, if any applicable to the legal profession in India, has to be followed. It is for the Bar Council and the Center to do that. And then their Lordships give directions how it can be done. So this was the position as it obtains today by virtue of the Supreme Court judgment. But the Indian legal profession as represented by the uh, Bar Association of India, which is the apex body of the legal profession, and more importantly, the Society of Indian Law Firms, in which we have about 125 top law firms of the country, you see, as members. We have taken a stand that we will not stand in the way of foreign lawyers coming into India. But then, in view of the Supreme Court judgment, the initiative is now with the government, firstly, to amend the law. The first step to be taken is to amend the Advocates Act to permit non-citizens also to practice law in India. Now, till that is done, there can be no possible way of permitting foreign lawyers to practice law in India. Therefore, the ball is in the court of the government. People were given this impression by the Bar Council also and by the government also that the legal profession in India is opposed to the entry, therefore we are not doing it. But now we have made it very clear. And in one of the very recent representations which we have made in response to a request made by the Department of Commerce, Government of India, which is the nodal agency, you see, for services sector, that we are not opposed to it. And the Ministry of Commerce has fully supported our stand, and their stand and our stand is identical. We have told the government in very clear terms that you please allow the foreign law firm because we are in favor of healthy competition, and it may also open up opportunities for our young lawyers who just come out of the law schools to find more scope for employment in really established law firm, whether Indian or whether foreign law firm. We have told them do it in phases. The first phase is to at least bring the Indian legal profession at par with the professionals outside, in the sense that we can at least publicize. I am not saying that we want to advertise. We want to publicize what are the strengths of our profession, what are the strengths of our law firms, that here is a law firm which deals with intellectual property rights, it's known for that. Who are the partners of that firm? What is the specialized areas, whether they are into patents or they are into trademarks or copyright. Similarly, infrastructure. Similarly, you see information technology or M&As and IPOs and all those things. So allow us to have, at the moment the Bar Council rules do not permit even having a proper website. Some law firms do have, but at least my law firm does not have, because being the president of the Society of Law Firms, I want to abide by law. Some of the law firms were even sent legal notices by the Bar Council that how come you are having a website? How come you are publishing some brochure when you attend some international conference? How come your entries are there in the law directories like Chambers and Martindale-Hubbell and all that? They received show cause notices that why your license should not be cancelled. So this situation has to be remedied, and remedied expeditiously. We have filed a petition in the Supreme Court. Supreme Court has given some directions that yes, certain minimum things you can have a website and you can put them on the website. Therefore, these restrictions have to be removed. The Indian legal profession needs to grow further, you see, higher. So first phase is to remove these restrictions, and second phase is to allow foreign law firms to practice law of their own jurisdiction in this country. That is the second phase, and this was done not just in India, it has been done in Singapore, in Hong Kong, in Japan, everywhere. The third stage would be to allow some sort of involvement of the Indian lawyers or some tie-up with the Indian law firms where they can practice jointly in certain selected areas, defined areas of practice. In Singapore, it has taken more than 30 years to come to the present state that even today, the number of law firms who can be licensed, foreign law firms who can be licensed, is restricted, is limited. No one can just as a matter of right say, okay, I want to open an office. They say, no, we'll have to, you have crossed now the number, you have missed the bus, therefore you cannot be, because if it was 100, you are 101, you are out. Similarly, in the matter of areas, defense, foreign policies and all that, there you see no foreign law firm is allowed to practice there. So that is the third phase. And the fourth phase and the natural phase is, okay, you allow them a full free hand to set up their law practice in India. Again, subject to certain restriction which the parliament or the government as an executive authority or the Bar Council of India as the regulator may like to impose. So this is the present situation so far as the legal profession's approach to the entry of foreign law firms is concerned. And I think if the government is keen that yes, foreign law firms should come, they must take immediate steps to amend the Advocates Act, then the Bar Council of India has the responsibility of framing proper regulations to govern the foreign law firms, because the present regulation may not cover, you see, such activities of foreign law firms which are there. Therefore, the main actors now who remain to take action are the Parliament and the government and the Bar Council of India, if we are really serious that foreign law firms should come to India. Otherwise, it is just another lip service to this cause. Thank you.